ready?
Yes, thank you.
Mr. Wolf? Yes.
I'm here. I can see you and Mr. Mould, but I can't see the other Lord Justices at the moment.
Right.
We may need to speak to then be pinned.
Yes, there's Lord Justice Green appearing.
I can pin him now.
I'm just coming on. Yep, let's try again. To go out and come back in again.
I think Lord Justice Haddon-Cave is just going to exit and come back in. So we'll wait.
I'm on.
Good. Thank you. So we're all here now. I think there's a slight echo which may disappear. I hope that's not disturbing you, Mr. Wolf.
I think that may be because two of the lordships are in the same room and your computers might be pointing to each other or too close, or I don't know.
We're in the same.
It's certainly not as good as it was before. It was much clearer before.
We're in the same place as this morning.
Ooh.
Is that better?
If it continues like that, it is intolerable.
Right.
And my mic's off.
I'll turn my microphone off and see if that helps us. I'm turning it back on only to invite. No, it's still echoing.
Lord Justice Haddon-Cave turns his sound down so that only your microphone and sound are working, my lord.
We've already done that, Mr. Wolf.
And I don't mind pressing on, but it's as long as you can hear me, that's the most important thing for the moment, at least.
We can hear you loud and clear. Is that better?
Yep, how's that?
It's much better.
All right.
It's improved then.
Mr. Mould?
Yes, it seems to be, we're now back to where we were at 105. Yeah.
I think we are. Thank you both for your forbearance. If it becomes difficult again, just let us know by raising a hand. I think that means We don't have a hand symbol, I think, available to us, but raise a physical hand. Off we go. Thank you, Mr. Wolfe.
Well, I'm grateful. I don't need to say any more about the grounds, other than just to return, if I may, to one small point in relation to ground 2. We had discussions during the course of the morning about the relationship between the two decisions, the 2017 process and the 2020 process.
Yes.
And what the role was of environmental information in the second of those. And I've made my submissions on the basis that the information needed to be known by and factored into the decision maker, and factored into the decision second time round. I don't want to lose sight of the fact that also there had been other changes. I think I may have mentioned this too quickly in passing. Whether or not there were changes in the underlying environmental assessments, there have been other changes in the environmental context.
Yeah.
If I can just ask you to return to page 52 of the supplementary bundle.
Yes.
That's the submission by Wildlife and Countryside Link. And in the third paragraph of that,
Yes.
they say this, HS2 ... Some environmental effects are inevitable in large infrastructure projects. The scale of loss associated with HS2 proposals is not compatible with national action to restore the environment or policies such as the 25-year environment plan, etc. Now that 25-year plan is a 2018 document. It's a 2018 plan. So whether or not the underlying impact assessments have changed, and that's not a legal issue for this court, the context for understanding those has changed. But as I say, even if that weren't the case, then those matters had to be factored in properly, and they weren't. Because I don't want for the moment to say anything more about the grounds, simply then on the other 2 points that are outstanding. On timing,
Yes.
taking the court's steer, I don't propose to say any more about that for now. You've got our written submissions and Mr. Moll's written submissions.
Yeah, so you...
Finally, on the Senior Courts Act point, it's not clear how vigorously this is now pursued, but just so that Mr. Mould knows the outline of our submissions, if he still pursues it, the original point was made, and this is paragraph 59 of the respondent's skeleton, by reference to the words in the Prime Minister's statement, and that's at CB 143, clinching case. Now, you have the material in Mr. Short's witness statement and exhibits, which you're seeing on a David Benning essay basis, which explains how, in context, that context was that this was very much a controversial decision, even within government. But the other thing you have, of course, is within the report itself. It said at page 124 that its recommendation was on balance. And then, interestingly, in the respondent's response to our application to admit Mr. Short's evidence in the first place, they say this, and I'll just read the passage. It's paragraph 5 of their response that came in yesterday. That documentation, in fact, does no more to illustrate the point well and clearly made by the Oakervee Review in paragraph 2.1 of the report, that the debate had been characterised by strong differences of opinion and merits of the high-speed rail programme. So their resistance to the admission of the information to show that the decision was balanced and controversial is to emphasise that it doesn't need to be admitted because we all know it was balanced and controversial. So in my submission, the section 31 goes nowhere, even on the respondent's own approach to the materials. So I would just put that in case Mr. Mould feels that he wants to deal with it. Unless I can assist the court further at this stage, those then are our submissions. We invite the court to go through the various steps on the way to granting permission for the appeal and ultimately granting permission for judicial review, and ultimately on the roll-up hearing allowing the judicial review on the grounds as identified.
Thank you very much. Let me just pause and make sure that neither of my colleagues wishes to ask any more questions at this point. Lord Justice Haddon-Cave has none, and Lord Justice Green also indicating none at this stage. Mr. Wolfe, thank you very much indeed. Very clear.
No,
and
I may, if it's okay to the court, just turn off my camera because I'm slightly struggling with bandwidth. So
yes, of course.
No offence is taken.
Not at all.
But I'm still, of course, listening and taking part.
No, we understand. Thank you. Yes, Mr. Mould.
Hello. If if I may, I'm going to make my oral submissions in support of our written arguments in the skeleton in the following order.
Yes.
Firstly, to say something about the decision, that is to say the decision of government on the 11th of February that HS2 should proceed. Secondly, the role of the Oakervee review and its report in the decision-making process. Thirdly, the factual context, focusing, if I may, on those matters that were in the public domain, therefore, in my submission, unarguably, matters that can be taken to have been familiar to members of the Cabinet and to the Secretary of State when the decision was made.
Yes.
Fourthly, the limits of public law challenge, given the nature of this decision. The Lordship in argument referred to it as a political decision. That was a submission I have made throughout this litigation, and that is exactly what it was. Fifthly, turning to make my submissions in response to ground 2, we've made fairly detailed written submissions, so I hope I can be forgiven for not labouring those to you. Sixthly, my submissions in response to ground 3b on the same basis. Promptness I'm content to leave to what I've said in writing in paragraphs 56 to 58. And if I'm still going, I might spend a minute and a half on section 31, 3c.
Right.
So firstly, the decision. You've seen the announcement. We have sought in paragraph 2 of our skeleton argument to encapsulate from the Prime Minister's statement what seemed to us to be the material words, if you will, by which he announced the decision. And as my Lord Justice Green observed this morning, the decision was announced as one made by Cabinet. Cabinet has given the green signal to high-speed rail. The decision, therefore, can and must sensibly be taken to have been a collective decision of the government. It was their collective judgment that HS2 should proceed. What did they decide to do? They decided to give the go-ahead with delivery of the government's high-speed rail programme, following consideration of the report of the Oakervee review, and that they should proceed with, or perhaps more precisely, continue with, the delivery of the Phase 1 railway scheme, which had been authorised by an Act of Parliament as recently as February 2017. Why did they make that decision? It is evident that they did so because they were strongly impressed by the transport planning and socio-economic benefits that would flow to the nation by the delivery of HS2 over the coming decades. That was their judgment is clear from the words that we have quoted from the Prime Ministerial statement in paragraph 2 of our skeleton. In a nutshell, what he said was, we, the government, decided that we should review whether to proceed with HS2 and if so how. The body entrusted with advising us on that have come back and said very clearly, yes, proceed, and we have taken the view that we shall accept that advice and we intend to proceed. May I just make the following point? As my Lord will know from his own past experience, when a major scheme of this kind comes forward, the product of the planning process is that it achieves development consent in European language, planning permission in domestic legal language. It's easy to forget what is involved in arriving at that stage in a scheme as large as a major infrastructure project such as the present. The process of evaluating the principle of whether the scheme in question should proceed is one that obviously involves drawing a balance between the benefits that are seen to flow from that scheme and the costs that will be incurred in the broadest sense in realising those benefits. But one of the things that Parliament, as decision maker in the present case, will have had well in mind was that the project has a very high capital cost. That is inescapable with the largest railway project that this country has seen since the days of Queen Victoria. And that it would also come with a very significant environmental cost, in the sense that it is impossible to construct a railway of scale that is here contemplated without the construction giving rise to environmental effects which are widespread and in some cases quite severe, however one seeks to mitigate them, and that the operation of the railway will also have environmental effects that are permanent and can be mitigated only to ultimately a relatively limited extent. The cost and benefit of schemes of this kind have traditionally been assessed in monetary terms by establishing what is known as the benefit cost ratio, the jargon of planners and infrastructure developers, the BCR. Mr. Wolfe took you to some paragraphs in the Oakervee Review report which set out in tabular form the benefit and cost ratio for this project a couple of years ago and more recently. And he demonstrated very effectively from the tables that the benefit cost ratio had gone backwards to some degree. The project produces less value for the cost of doing it now on the assessment than it did back in 2017. It's still positive, but it's not as positive as it used to be. The reason why that has happened, as is evident from the Oakervee Review report, is because the estimated capital costs of construction of the railway are now recognised to be considerably greater than they were when the scheme was being considered 2 or 3 years ago. And it is that fact, as is evident from the way in which the decision to carry out the Oakervee Review was announced last summer by the then incoming government, is that fact that there was a source of disquiet as to whether the capital costs of construction had become so burdensome to the economy and to the public purse that they had arguably come to outweigh the benefits that would flow from the delivery and operation of this railway scheme. That is admirably illustrated by the tables that Mr. Wolfe showed you. The government's judgment was that despite that increase in cost, the benefits were still worth realising. That's the effect of the decision in February. So it was, as the Divisional Court said in paragraph 19, a decision based on a cost-benefit analysis of the scheme through the Oakervee Review process. What had not changed materially since Parliament chose to legislate to enable the scheme to be delivered is the environmental impacts of the project. You will struggle in either the Oakervee report or any evidence that has been presented to you to find anything that supports the argument that the environmental impacts of the railway scheme, whether in construction or operation, had changed materially since the days of the scheme, of the bill, the Phase 1 bill's passage through Parliament, and the days, and early this year. It was, of course, the case that a variety of environmental campaign groups and bodies of the kind that Mr. Wolfe showed you submissions from earlier this morning continue to assert in very forceful terms, as they have always done, that the environmental cost of HS2 is simply intolerable, and that its benefits have been overstated. But that theme has been a constant theme. And the frank position is that Mr. Oakervee and his colleagues, in receiving those documents, carefully and persuasively drafted as they were not being told anything that was significantly new about the scale of environmental effect that the railway would have. I shall come back to that a little later, but that is an important point of context in my submission that the court needs to bear well in mind. May I just turn briefly to the question as to who made the decision? As I indicated, the Prime Minister was clear that it was a decision of Cabinet. Would your Lordships kindly turn to the supplementary bundle?
Yes.
And if you turn, please, to page 310. You will find the Government Legal Department's response to the pre-action protocol letter which Mr. Packham solicitors wrote in March of this year, to which Mr. Wolfe drew your attention briefly this morning. Letter dated the 11th of March. And this, Wolfe forcefully argued, was the source of confusion as to who had made the decision. If your Lordships look at paragraph 3, you'll see that the reference that this letter made under the heading proposed defendant to the Secretary of State was to the fact that as Secretary of State for Transport, he is the minister responsible for transport matters within government, and as such would be the appropriate defendant in this action. In my submission, there is nothing in the slightest bit remarkable or confusing about that observation. The implication of Mr. Wolfe's submission is that the letter ought to have said, this is a decision that was made and is subject to collective Cabinet responsibility, and so every member of the Cabinet could be identified as a potential defendant to this action. That is nonsensical. In my time in practice, I have never come across a case in which 25 or 30 ministers have been identified as defendants on the basis that the decision, as is often the case, is one that was made by Cabinet collectively, and therefore each of them should be identified in that way. But what is absolutely clear from the response, pages 311 following in the bundle, paragraphs 7 through to 18 in the letter, is that the decision was attributed to government. I needn't read the passages out to you laboriously, because the court will read the letter for itself. But the letter was consistent with the Prime Minister's statement on the 11th of February. And that theme is carried through in the evidence of Mr. Haslam, pages 344 and 359, and in the evidence of Mr. Stewart at page 38 in the respondent's witness bundle.
Sorry, the page references for Mr. Haslam again.
344 in the supplementary bundle.
Yeah.
And 359 in the supplementary bundle.
Yeah.
And Mr. Stewart, page 38. May I give you the paragraph references, unless the court wishes to go through it, I'm not proposing to take you to them.
Yes, thank you.
Paragraph 7 in Mr. Haslam's first statement.
Yeah.
Paragraphs 3 to 10, Packham, in Mr. Haslam's second statement. Paragraphs 5, 14 and 15, 20 and following in Mr. Stewart's witness statement. And it is reflected in the document that was foreshadowed in February and which Mr. Haslam referred to in his his first and second statement. That is to say, the business case for HS2 that was published, I think in April of this year, of which you have extracts exhibited to Mr. Stewart's witness statement. And may I just take you briefly to the executive summary of that document, which you'll find, if my calculation is right, beginning at page 51 in the electronic witness bundle.
Right, sorry, Mr. Stewart.
Mr. Stewart's exhibit.
Yeah.
You'll find that the only exhibit that he produces, I think, is quite some substantial extracts from the full business case I Speak to Phase 1, published in April of this year. And if you find the executive summary, which is internal page 6, and I think electronic bundle page 51,
Yes.
you will find paragraph 1. On the 11th of February, the Prime Minister announced that the government intended to proceed with High Speed 2, having considered the conclusions of the independent review of HS2 led by Douglas Oakervee and wider advice. This was based on evidence that its potential to redistribute opportunity and prosperity across the country, providing much needed future rail capacity, and support the 2050 net zero carbon objective continues to outweigh its costs. And then I draw your attention to paragraphs 9, 14, and 25. And because it is, again, unless you would wish me to, I won't read them out.
No, let us just look at them, if you would. You needn't read them.
9, 14, and 25.
Thank you. Yes, thank you.
And I particularly invite you to read 25 because, if anything, encapsulates the political nature of this decision on the broadest basis of socio-economic judgment, which is the job of government to fulfil. It is that paragraph.
Yes.
And so, if I may, that is what I wish the court to take from me in terms of the nature of the decision that the court is being asked to review. I turn then to the second of my themes, which is the role of the review and its report.
Yes.
Mr. Wolfe has largely covered this. We deal with it in paragraphs 3 to 10 of our skeleton, and we draw attention in particular to the Divisional Court's encapsulation of the role of the Oakervee Review in paragraph 19 of the judgment, which appears not to be in dispute and which we certainly invite this court to endorse. That is to say, a cost-benefits review, essentially, undertaken on a short timescale. My Lord, Lord Justice Green characterised it non-pejoratively as a quick and dirty review. If I may say so, with respect, that is a neat alternative, a neat paraphrase in a single phrase of the way in which the Divisional Court characterised the process. What I would emphasise is this. Its role was to examine the existing evidence. And the existing evidence in environmental terms and that is to say, insofar as the project would have environmental effects, which were both positive and negative, was, for the reasons I have stated, almost entirely to be derived from the large body of environmental assessment and environmental reporting that had accompanied the passage of the Phase 1 bill, and which accompanies the Phase 2A bill, which is presently before a select committee of the House of Lords. Things are a little further into the future for Phase 2B. Work is in progress now, with a view to depositing in a bill later in the course of the current Parliament. But the same process of environmental assessment will, of course, be required unless Parliament changes its standing orders, which is unlikely, I would suggest, to happen. The second is, and this is Mr. Wolf helpfully confirmed this in argument, this was not a public consultation process. And that is important because, of course, were it a public consultation process, that might have imposed certain responsibilities at common law in the light of the decisions such as gunning, to be seen to have read conscientiously responses and things of that kind. Paragraphs 9 and 10 of the skeleton argument, our skeleton argument, are an attempt by us to draw out a little the logic of what the minister said when he introduced the chairman's stocktake report and said a little more about the nature and function of the Oakervee Review on the 3rd of September of last year, which Mr. Wolf took you to this morning. And our point is that it was not suggested that ministers would regard the review as a self-contained, freestanding and comprehensive account of the advantages and impacts of HS2. Mr. Wolf, in writing and this morning, emphasised the rhetorical flourish of the Secretary of State, referring to a blank sheet of paper. It is in the nature of experienced politicians to give emphasis to the points that they wish to make by flourishes of that kind, as your lordships will readily accept. What he meant was that he wanted to approach the matter with an open mind, and that his cabinet colleagues would do the same. But it clearly not to be taken as saying that that open-minded approach would assume that the Big Bang took place on the 21st of August 2019. It would be based on an appreciation of other things that ministers and their officials judged to be relevant to the decision whether or not to proceed with delivery of the project in February of this year. And you have the point about timescale, which I think, again, Justice Green mentioned in argument earlier. This was a very, in timing terms, this was a circumscribed process. I, of course, am not to be taken to seeking to diminish its significance. The government commissioned this review because it thought it was an important stage in the process in order to give public confidence in a decision to go ahead further with HS2 if that was the outcome of the process. But it does bear comparison in terms of the detail of assessment, for example, of environmental impacts, with the extraordinarily detailed and thorough and prolonged process that preceded the enactment of the Phase 1 Act in 2017. So that is the Oakervee review. What then of the my third theme, the factual content, a factual context rather, that is set out in the Divisional Court's judgment in paragraphs 7 to 17, and again, there's no issue about the accuracy of that account. And Mr. Stewart confirms the factual background in terms of the legislative history in paragraphs 8 to 13 of his statement on page 38 of the electronic bundle. Mr. Miller, the environmental director of HS2 Limited, in his second statement, gives an account of the breadth and depth of the environmental impact assessment work that was reported to Parliament in support of the Phase 1 bill. That's the paragraphs 15 to 27 of his second witness statement, pages 125 and following. And in his exhibits, beginning at pages at page 141, there is an extract from a volume of the main environmental statement, which was concerned with the assessment of the impact of the railway project as it passed through the central Chilterns. And that was put in to show that, amongst other things, there was comprehensive consideration of the impacts of construction and operation, largely a tunnelled railway in that section of the route, the impacts of that on hydrogeology, and in particular on risks of impact on the river Misbourne, and on the I do apologise, that wasn't supposed to happen.
Well, certain things are beyond our control, Mr. Moore.
It's been addressed, I hope. And also Shardlow's Lake, which, as you would have seen from some of the appellant's materials, were highlighted as elements that were not covered specifically in the Oakervee review report, in the 5 or 6 paragraphs that deal with environmental impacts. There is also an extract from a supplementary statement, pages 183 to 209, which reflected some of the changes that were made to increase the length of the tunnel through the Chilterns in order to relieve some of the impacts on communities in that sensitive part of the country. Those are simply to give a court a flavour of the degree to which the matter was assessed at that stage in the process. In terms of climate change, you have the evidence of Mr. Moran, who speaks as the officer within the Department of Transport, who has particular responsibility for that aspect of transport planning and delivery. He deals with the significance of the Paris Agreement, the role of the Climate Change Act. He explains the government's clean growth strategy, and he explains how, within that statutory and policy framework, as it was in February 2020, and indeed as it remains largely unchanged, I think, now, how the impact of constructing HS2 and the carbon emissions that will be generated by that process, how those would be managed under the aegis of those statutory and policy tools and techniques. All of the matters that I just mentioned were in the public domain in February of this year, and they were, and insofar as government is concerned, central to government policy at that time. So one takes climate change. Climate change has been a key element of government policy, as this court knows from the work that has from previous decisions, has been a key element of government policy and indeed legislation for some years now. So again, any suggestion of a blank sheet of paper must be calibrated against those those factual and legislative contextual matters. And the reason why I drew attention to paragraphs 2.3 and 2.4 in the Oakervee Review report, which Mr. Wolf very kindly read out this morning, was because Mr. Oakervee effectively in those paragraphs was reminding the reader that there was a very deep and wide context, the report and the conclusions that he drew in the report that he wrote.
Yes.
I turn then to the fourth theme, which is the limits of public law challenge, given the nature of this decision. We've dealt with that in paragraphs 20 to 25 of our skeleton, and we have invited the court respectively to
You said in opening submissions that we infer that if a matter was in the public domain, then the cabinet would be assumed to have knowledge of it. Is that entirely logical? They might or might not. I can see that they may have knowledge that a decision was taken about all of those facts and matters, complicated, voluminous facts and matters, and that it received approval. But would they necessarily be deemed to know all the nuts and bolts behind that approval?
well, if there are 2 points in response, if I may, my lord. The first is this: you were shown the cabinet manual earlier, and you were shown 3 paragraphs. I think it was around 423 or thereabouts of the cabinet manual, which indicated that, as a matter of course, when cabinet is asked to consider to make decisions on cabinet agendas, briefing papers are prepared, reports are prepared to ensure that the cabinet is properly briefed as to the relevant factual, policy and other material. It's certainly my submission that there is no reason in this case for this court to assume other than that course of dealing was followed here.
What does that mean in practice? I mean, experience indicates that the sort of material put in front of secretaries of state in briefings or the cabinet in briefings, they're not going to provide a summary of every aspect of the environmental assessment which has gone on for years before, but it might say, in broad terms, this was what was considered and it was approved by the following process.
Yes, and it might say the full range of environmental impacts of the scheme were comprehensively considered, and nothing significant has changed since Parliament undertook that process, culminating in the Act in 2017.
That's more likely.
Sorry?
We don't know for certain, but that's more likely. I find it improbable that the cabinet would all have gone away and done their homework, taking weeks and weeks and weeks, poring over all the pre-existing environmental assessments. It's not the way it works.
And if I gave the impression that that was what I was asking the court to infer, then I'm immediately happy to disabuse you of it. Of course, your lordship is right. But we're actually here dealing with the fundamentals of the court's approach to judicial review. The court has always proceeded on the basis that it should not assume that a decision maker has failed to take account of considerations that are material to its decision, but rather starts from the position that the decision maker will have taken account, so far as necessary, of considerations that are material to its decision. There was the famous encapsulation of the proposition by Lord Lloyd in the Bolton case in, I think, 1995. It's not in your lordship's authorities, but it's sufficiently well known to planning practitioners, I think, for me to put it in that way, where he said that where there was a reasons challenge to a planning decision, the court would not draw the adverse inference that there were not good reasons for the decision unless everything pointed to the contrary conclusion. that's an important facet of the court's approach to a Wednesbury challenge, which is the basis upon which the argument is put in the present case. There used to be a Latin maxim, I think, reflected there, on the Clausing Munter and so forth, but I better not articulate that. So that's an important point, because Mr. Wolfe comes close in some of his submissions to suggesting that it's for the government and for Cabinet to prove or to establish that it did, or that members of Cabinet did know things, or had gone away and looked up what the impact on wildlife and so forth were. That is assuredly not the approach that the court takes to proceedings of this kind.
Mr. Mulder, are you effectively saying that the correct approach is that the court can assume that in any briefings for Cabinet members that the main findings of the environmental reports and so on would have been included in those briefings, or what?
Yes, the court can assume. I can probably cut through this actually. Yes, I am saying that, but I can cut through this actually by going straight to a paragraph in the Oakervee Review report itself. Why don't I just take the court to that straight away? It's in the supplementary bundle at page page 158.
Yeah.
And you'll see that in introducing the topic of localised environmental impacts, the report said, in addition to carbon emissions described in section 5 above, it's also important to note other environmental considerations, including impacts on woodland landscape biodiversity, and more broadly, on built and natural environments. Though such impacts are in many ways unavoidable on a project like HS2, it's vital that appropriate mitigation and compensatory measures are implemented by HS2. In other words, please bear in mind, Cabinet, that such is the scale and nature of this project, that it is going to have broad environmental effects, both on nature and on human beings, on communities. And they are, given the nature of what HS2 involves, the construction and operation of an intercity railway line, they are to a large degree unavoidable. In other words, they're a fixed point.
But it's not exactly saying clearly the first 30 years are going to be bad news, but then we'll get into the benefits.
That's said earlier. That's said in relation to carbon. But here, it is saying, and one can, if one thinks about that paragraph for a moment, think of some of the things that are not mentioned in this and the following 5 or 6 paragraphs. Noise. Now, anybody with any sense will recognise that the construction and operation of a high-speed railway line between London, Birmingham, Manchester and Leeds is going to have significant and quite widespread noise effects, both during its construction and operation. Anybody with any sense will realise that the construction of a civil engineering project of that scale is going to involve prolonged and heavy goods vehicles on the road network for a period of years. Anybody will realise that the construction of a linear scheme of that kind is going to involve widespread and significant effects on agriculture, both in terms of land take and the consequent effects on farming business, and on communities, the impact of severance, which a linear scheme implies, for example, on public rights-of-way networks, and where villages are close to the line, and houses are on one side and shops are on the other, and that kind of thing. It's a tunnelling scheme in very large part. There are many kilometres of tunnel along the phase 1 route and more on further phases. And so it's going to have the potential to have effects on hydrogeology in terms of the impact on groundwater and the impact on surface water. Now, none of those things is mentioned in terms in paragraph 6.14 to 6.21 of this report. But is it seriously to be suggested that the reader of this document, and in particular the reader of paragraph 6.14, wouldn't immediately have recognised that under the rubric impacts more broadly on built and natural environments, those were the kind of impacts that the writer of the Oakervee Review report was drawing to the reader's attention. What this document was saying in these passages was, if you want to realise the benefits of HS2, you have to accept that those environmental impacts across a range of environmental subject matter, if you will, that they are to a significant degree inescapable, unavoidable.
Mr. Mould, I wonder if I could just join this sequence of questions by bringing us back to the terms of reference on SB 44.
Yes.
And I'd invite your response on this question. The second paragraph says, under purpose, for the whole HS2 project, the review should rigorously examine and state its view on, and then the second bullet point is the full range of benefits from the project, including but not limited to, and then the fourth sub-bullet is environmental benefits.
Yes.
And then the third main bullet is full range of costs. And the question, it's a relatively broad question, is this. How did the review ultimately discharge those specific terms of reference? And that, I suppose, is linked to the question, were they in fact being invited to rigorously examine and state a view on environmental harm by contrast to benefits?
In relation to the first bullet, which you drew to my attention, environmental benefits,
Yeah.
the review discharged that in the passages that Mr. Wolfe draw to your attention in section 5 of the report.
Yeah.
That is to say, paragraphs 5.30 through to 537 and conclusion 5.
Yeah.
Insofar as environmental costs are concerned, the review was not asked specifically to focus on that, but the review did, as part of its desire to provide a comprehensive assessment of both cost and benefit, it did produce those paragraphs from 6.14 onwards and conclusion 5, to which I have referred the court. And it did so, no doubt, in part, because, as Mr. Wolfe has pointed out, those who contributed submissions to the review before it concluded its work included a number of environmental bodies who raised concerns of that kind. And so it wanted to be true to those people and to report those matters to government. And that is why in paragraph 6.16 and 6.17 it focuses on ecology and woodland, because that was the focus of the representations that it had received, as you saw earlier this morning. But my theme is that it was certainly in no way inaccurate or a failure, a dereliction of its task to provide a thoroughgoing report of the costs and benefits of HS2, to provide a relatively short summary building on the theme that is set out in paragraph 6.14. That is to say, the environmental impacts are known and they are essentially unavoidable. But there is an opportunity, given the duration of HS2 and the construction phase, to keep the response in terms of mitigation and compensation to those impacts, to keep that response under review, and to take the opportunity to improve on and to extend the mitigation measures and the compensation measures where that can be done. And that is the essence of conclusion 8, which concludes this short section on page 160.
Can I throw something else into the mix? And I think my observations have two parts to them. First of all, the context to the report. The TOR, I think one can perhaps politely describe as ambitious, given the task that was being set for a 2-month exercise. And the chairman in his report, I think, recognises this as SB 116, where he recognises that the review faced a major challenge to undertake what he describes as a deep examination of the areas of the TOR, but he said, and then he used the word though, which I think is possibly relevant, that they provided views on key issues. And I'm not at all surprised to see a chairman preparing the draft, which was probably only a couple of months after the TOR was agreed, basically saying, well, being polite, this was over-ambitious, but I've done my best and I've given you the views.
Yes.
And you know, we're not talking about a statute which the chairman has breached by not complying with every aspect of the TOR. It was ambitious. But that was the document with that caveat which was placed in front of the cabinet. And going back to the issue which I think Mr. Wolf has raised, is what was in front of the cabinet. It seems to be as relevant that this document with that limitation was in front of the cabinet. And it's in that context, I think you accepted that it's not said that anyone in the cabinet went back and actually looked at all of that underlying evidence. I think you asked us to infer that they must have taken the environmental analysis, as it were, as approved previously. And I can see that that fits in with your submission. But what I would like to know is why the documentation just identifying what it was before the cabinet is not being disclosed. You're asking us to speculate, and I can see that we could speculate and come to a conclusion, but it would have been easier for us just to be given the information.
Well, the case that was put against us was that the report misleadingly
I'm so sorry to interrupt, but I've just been told by my leader that he's dropped out of the connection, so to let the court know.
Thank you. Thank you, Ms. Golden. We'll stop and we'll wait for Mr. Wolf to come back. Thank you very much for letting us know. I don't know if there's anything we can do at our end to help.
If he goes out and comes back in, that may work.
Can you send him an email to suggest that, do you think, Ms. Golden? Would that,
Yes, we'll do now.
is that possible? Thank you.
Yes, my lord.
Failing this, Miss Golden, I wonder whether a telephone connection would be possible. I think he's back.
I think I'm back.
Good. Yes, we can hear you and see you. Marvellous.
I'll turn off my video again, but be reassured I'm back. Thank you very
All right.
much.
Now, but what did you? But the question is, what did you miss? And we need to be clear about
Just
that.
the last thing I heard was Lord Justice Green saying to Mr. Mould, the question, Mr. Mould, is what was before the cabinet, and that's the point at which it
Yes.
just got to get the answer and dropped out.
All right. Well, so that was the question that my lord asked, and Mr. Mould was just about to answer it when Miss Golden kindly alerted us to the fact that you weren't.
Thank you very much.
Linked in it at the moment. All right. Yes. Off we go then, Mr. Mould. Your response, please.
Yes, my lord, the nature, the answer is this, if I may. We are here dealing with a Wednesbury challenge to a decision by government which is made essentially in the exercise of a common law power, if you like. There's no statutory framework against which this decision was made. It's not made in the exercise or the discharge of any statutory duty. There is no minister who has responsibility under any legislative framework for it, and there is no procedure set for it. It is therefore a decision which is only amenable to review, if you will, on the most basic Wednesbury grounds. It is not the intensity of review that this court should properly engage in should be commensurate to that state of affairs. It is not ordinarily, in those sort of cases, not ordinarily the respondent's approach to disclose cabinet papers to the court, but rather to seek to encapsulate in relatively straightforward terms what was the subject matter of the decision, and give an indication of those matters that Cabinet took into account and the information that it had before it. And it's that approach which you see reflected in the evidence of Mr. Stewart. Now, I appreciate, of course, the point your Lordship puts to me, that there must have been papers. I mean, that is obvious, not least because of what is said in the Cabinet Manual. But I would frankly say that the court might have been surprised in a case like this to have seen Cabinet documents of that kind produced. There are, of course, contexts in which the court would expect and would call for material of that kind. Cases which involve matters of great sensitivity involving personal liberty and that kind of thing.
Mr. Moles, I think my point is slightly different. I can well see that you can advance your case on the basis of the Oakervee report itself and its limitations and what we can properly reasonably infer from it. If your response is that we're invited to infer that the Cabinet, named individuals, did as a matter of fact have certain documents in front of them or did proceed on a certain premise, for example, that they should simply take all the prior environmental assessment as approved, which is entirely plausible and reasonable. That's a pure question of fact, isn't it? One would have expected it to be dealt with. It may be that it just evolved in argument, but I'm slightly uncomfortable about just being invited to infer something which could be established one way or another purely as a question of fact as to what the premise was.
No, and forgive me, I think I misunderstood your question and I apologise. I'm certainly not inviting the court to proceed on that basis. And the reason I smiled earlier when Mr. Wolfe was suggesting otherwise was that I was surprised that he had thought that was our case. The case put against us on ground 2 is that the report itself would have caused the reasonable reader to have assumed that the Oakervee review process had carried out its own assessment of the environmental impacts of HS2, and that the product of that assessment had concluded, that the only material impacts were those that are reported in paragraph 6.14 to 6.21 of the report. That was the way in which the case was put in the pleadings, and the way in which was argued in the skeleton argument that was presented with the appeal. My answer to that, as you would have seen from our skeleton argument, is that it is absurd to suggest that a reasonable reader would have read those few paragraphs in that way. Nobody with any sense would have read that as indicating A, that the review had carried out a comprehensive assessment of the environmental impacts of HS2, and nobody with any sense would have thought that that process had resulted in so limited a range of environmental effects as those that are specifically referred to in paragraphs 6.14 to 6.21 of the Oakervee Review. And I hope that reassures. In other words, I'm prepared to ask the court to assume that ministers in cabinet can be equated to reasonable readers of the report. And on that basis, that if a reasonable reader would not have read the report in the way that Mr. Wolfe must persuade you if he's to get Ground 2 off the ground, then it follows that Cabinet would not have read it in that way. And paragraph 6.14 is as good a way of illustrating that, because what paragraph 6.14 very plainly does not do is to assert in any shape or form that the Oakervee Review has itself undertaken any sort of significant assessment of the environmental impacts of HS2. Rather, it says, we note that the environmental impacts, which range broadly both across the natural and human environment, are to a large degree, paraphrasing it, to a large degree unavoidable. There was no suggestion in the report that they had changed materially, and there's no reason for the court to infer that the Oakervee Review got that wrong. Not being suggested that the Oakervee Review got that wrong. What the review was about was saying, because they're unavoidable, they're a fixed point in the assessment. The way forward is to keep the mitigation strategy under review, because the duration of the scheme allows real opportunities to try and improve on mitigation of the environmental effects. Now, my case is that the reasonable reader would have read those paragraphs at face value and understood that that was the what those paragraphs were leading to. They were leading to conclusion 8 on page 158. On page 160, rather.
Paragraph 49 of the Divisional Court's judgment records a concession by Mr. Wolfe that it was a matter of judgment for the chair as to how far the review should go in respect of the topics. Picking up my Lord Justice Green's point about the TOR, and you say presumably that helps your case, that we're straight into Wednesbury and no stopping in a sense, and that if and insofar as the scope of the review was fashioned by the words of the foreword by the chairman, then that is what everybody should have. That was the starting point for any consideration.
Yes. Very much so. I mean, our essentially we're doing Ground 2, and none the worse for that. But in our scope, we seek to draw distinction between what we understood to be the claimant's argument, and I think that's been borne out by what he said to you today, in paragraph 28.
I think you've lost Mr. Wolf again.
Oh,
He just flashed up on the screen saying David Wolf has left the meeting.
Right.
right. Let's pause again. Miss Golden, are you with us still?
Yes, my lord.
I'm sorry, I think we've lost Mr. Wolf again. Could we do the same again? Could you possibly send an email to him, please?
Yes, I'll email.
That's very kind. Thank you for that.
One solution we've used before is to set up, as my lord has said, a telephone and put it near your screen. And it seemed to work well before, if he keeps cutting out.
I think he's back. Yes.
My lord, yes, I am back, and actually what I managed to do that time was to get the live stream going on my phone, so I don't know if I missed anything significant. I was watching it in the live stream. So
Well, thank you for that. Let's hope that helps us. But just to make sure that you've not missed anything, we need to go back. My Lord Justice Haddon-Cave had asked about paragraph 49 of the Divisional Court's judgment. Did you?
I had those exchanges. Yes.
You heard that exchange. Can you just track back to that, do you think, Mr. Mould, so we can be sure that Mr. Wolf hasn't missed anything?
I think Lord Justice Haddon-Cave asked me if I sought to rely on what was said by the Divisional Court in that case, in that paragraph, and I said that I did.
Yeah.
And I think I was then about to go to my skeleton argument.
Right. So I think on that basis you've missed nothing, Mr. Wolf.
I think that's right. I'm grateful.
Then we'll go. We're now going to your skeleton argument, Mr. Wolf, Mr.
Yes.
Mould.
I was simply going to, I think essentially in wrapping up on strand 2, as we've covered that, I think over the course of the last 20 minutes or so.
Right.
Paragraph 28, or page 10, paragraph 28. I set out the two relevant passages in the Oakervee Review report, paragraph 2.2, and then the paragraphs we've been looking at in section 6. We then encapsulated the appellant's contention from paragraph 19 of his skeleton argument as being that those paragraphs were presented as providing up-to-date assessment based on all the existing evidence of the environmental impacts of the project, and were so understood by, I shall substitute the words government or the cabinet, as it were, that I believe to be essentially an accurate encapsulation of what of the basis for the submission against me. And then we answered it in paragraph 29 by saying that no reasonable person reading those paragraphs against the background of public knowledge about HS2 in 2020 would have read the Oath report in that way. They can't sensibly be read and seek to fulfil that purpose, let alone possibly have misled the respondent into thinking that was what the review was purporting to do in those few paragraphs of the report. And I've sought to explain, to justify that position in my submissions to you. And then I've set out what we contend was the true purpose, as the reasonable reader would have taken it, of those paragraphs of the report in paragraph 30. That is to say, that it's drawing attention to the opportunities against the background of unavoidable environmental effects to seek to improve the mitigation and compensation over the course of construction and operation of the project. And that was the basis of conclusion 8 of the report. And then this, I think, it touches on a question put to me by my Lord Justice Green. I've suggested that that is consistent with the terms of reference in paragraph 31. I've suggested in 32 that the writers of the report were well aware of the environmental work that had been done. That was part of both the existing evidence, paragraph 32, and I suggest that it would have been obvious to the reasonable reader that those paragraphs had been based on some consideration of that body of existing evidence. And then summarise the position in 33. And to come back to the question that my Lord put to me, about 5 lines into 33, it would have been obvious to the first respondent, shall we say ministers, reading those paragraphs, that if they wished to remind themselves, so if they wished to remind themselves of those impacts, how they've been assessed and the measures in place to address them, then they needed to look at the body of published material. So not that they did necessarily look at it, but it was available to them, and the report was sufficiently pointed to the reasonable reader to suggest that it had drawn upon that material in order to write the few paragraphs that are included at 614 to 621. If that is right, we say it is, if that is right, then the gravamen of the complaint which supports ground 2, which was that there was a material misunderstanding of the range and extent of the environmental effects of HS2, is based on a misconceived premise. That misconception is this: precisely approaching what the report actually said and conveyed to the reasonable reader, no reasonable reader could have been misled into thinking that the report was doing other than briefly to summarise some key aspects of the environmental effects of the railway, and to suggest that there was an opportunity hereafter to do further work to seek to mitigate and to compensate for them. And that is why we suggest that this part of the report was less to do with whether to proceed with HS2, but more to do with how to proceed with HS2. And you'll recall that the Secretary of State said in announcing the review back in August of last year that its purpose was not only to consider whether, but also to consider how. And my Lord Justice Lindblom's point, it's interesting that you don't see any reference to wider environmental effects in the terms of reference and in the litany of costs that the report was asked to consider. That is consistent with that approach. This wasn't seen as being a factor that in itself was likely to be determinative of the question whether or not to proceed. It was more to do with whether there were opportunities to improve the environmental performance of the railway in the event that it didn't. That in turn is consistent with my submission to you that the environmental effects of the railway, both in construction and operation, was one of those matters that hadn't really changed in any significance, to any significant degree, between the enactment of the 2017 Act and the quick and dirty review that the Oakervee process represented. So that is, in a nutshell, our response to ground 2, and it doesn't depend upon drawing sophisticated inferences as to what members of government did or did not know, and as to whether they took the opportunity to avail themselves of further information. It is simply based upon the reasonable readers, on a reasonable reading, an objective reading, if you will, of the document itself, and an understanding of what lay behind it in public knowledge at the time when it was written and received in the early months of this year. What Mr. Stewart's evidence does is...
Can I just ask you, you say what lay behind this in terms of public knowledge. What is the absolute bare minimum that you say would provide context? I mean, I say it must have been obvious to everybody that the planning permission had been granted.
And that it had been supported by a comprehensive environmental impact assessment, which had addressed thoroughly the full range of environmental effects, positive and negative, that the railway was predicted to, the construction and operation of the Phase 1 railway was predicted to give rise to.
And because there was planning permission, then the assessment of the environmental impact was positive, but the right or obvious likelihood of there for this purpose. But that is the bare minimum that would provide the context of this report. Everybody would seem to know at least that.
Yes, the strict way of putting it, consistent with environmental assessment law and parliamentary rules, shadow the rules that apply to decision makers under the planning legislation, would be that there had been a thorough investigation an analysis and assessment of the environmental effects of construction and operation of the railway, and that assessment had been taken into account by Parliament as decision maker when the Act was in progress through its various parliamentary stages. One of the things, for example, that is required under parliamentary standing orders, I hope you'll take this from me, without the need to support it with but at second reading, parliamentary standing orders require an independent assessor to report a summary of the key points made by the public in response to and commenting on the environmental statement that is submitted alongside the bill when it's deposited in the House. And at third reading, the Minister is required to give reasons for to give a statement of reasons in relation to the key environmental matters that have been considered and reported along with the bill, so that it shadows the requirements which arise under the Environmental Impact Assessment Directive, for example. But I don't, in my submission, I don't need to ask the court to assume anything more than that. And indeed, I am conscious that if I seek to go further than that, it can begin to create the sort of difficulties in terms of the evidential basis of the submission that my Lord has put forward. Yes, thank you. So that is ground two. I was going to deal with the legal framework. Perhaps it's convenient, particularly given the time, if I was to go straight to ground 3B.
Yes.
And then, if I have a few minutes after I've dealt with that, just to summarise a couple of points on the law.
Yes. Thank
so
you.
on ground 3B, here the following points, as I understand it, are not an issue. The net zero objective, which was agreed to by consenting parties to the Paris Agreement, that is now enshrined in statute by virtue of the amendment to the Climate Change Act in 2019. Secondly, paragraph 5.30 of the Oakervee Review Report expressly acknowledged that change in the law, and that current state in the law, in UK law. Thirdly, the Oakervee Review Report, paragraph 5.31, expressly acknowledged that the construction of HS2 would generate substantial quantities of carbon emissions. Perhaps a statement of the obvious, given that it's a huge civil engineering project which will require the pouring of very large quantities of concrete. Fourthly, that conclusion 5, which is the conclusion drawn following those few paragraphs 5.30 to 5.37 on this question. Conclusion 5 advised that the ability, certainly in regard to phase 1, and the construction of phase 1, to reduce the quantity of carbon emissions generated during construction was limited. There might be more opportunities with later phases. It's accepted by Mr. Wolfe that each of those matters was drawn to the decision maker's attention by the report itself. The narrow ground of complaint is that despite their knowledge of those matters, ministers failed to recognise that the generation of those carbon emissions during construction would have an impact on the realisation of the statutory and policy initiative to secure the progressive reduction in UK carbon emissions over the decades leading up to 2050. In other words, the process that in statutory terms is enshrined in the carbon budget element of the Climate Change Act, and which in policy terms, for example, is promulgated through the clean growth strategy that Mr. Moran refers to in his statement. Our answer to that in paragraphs 38 to 55 of our seventh arguments. In this context of a pure Wednesbury challenge, the court is able readily to infer that ministers would have recognised that those carbon emissions generated by the construction of the railway would need to be countered by the deployment of the initiatives, the techniques, the tools which form part of the pathway or pathways towards progressive carbon reduction under the carbon budgets and through the implementation, amongst other things, of the clean growth strategy. But it's important that the court understands the perspective from which the Oakervee Review was reporting these matters. And that perspective is that the report was looking at the comparative performance of high-speed rail as a candidate for securing progressive and long-term reduction in transport emissions in comparison to other potential candidates for delivering the required major increase in transport capacity. And those candidates were either building new motorways or I suppose, an increase in airport capacity. And your lordships see that very clearly from paragraph 5.32 of the Oakervee Review. You can find at page 50 in the supplement bundle. Having acknowledged clearly in 531 that construction of HS2 would be a significant contributor to carbon emissions, 532 said this: it's then important to consider the carbon impacts of HS2 against alternative ways of managing increased demand for travel. The review notes that HS2 could in fact be less carbon intensive than other non-rail alternative transport schemes which deliver similar transport outcomes. This includes, for example, the construction and operation of new motorways and of new runways or airports. So unless one was going to adopt a do-nothing scenario, that is to say, allow transport demand to grow without any initiative to meet it, one had to make a choice, if you will, the least worst alternative in terms of performance on climate change. And it's, of course, obvious to the court, it will be obvious to the court as it would be to the reasonable reader of this document, that none of those alternatives, whether they be new motorways or new aviation facilities, none of those could be constructed without themselves generating very substantial additional carbon emissions. So the choice could hardly be made on the basis of a comparative performance in terms of construction. The choice would have to be made in terms of the long-term opportunities that each of those comparative modes of long-distance transport would provide in the operational phase. So once the burden of construction had been passed and the transport mode was coming into use, and it was there at that stage, as the court states in paragraphs 533 and following, it was there that HS2 began to achieve a comparative advantage. Thus, long-distance rail travel was much more likely to realise an overall reduction in carbon emissions through transport between cities than accommodating substantial growth in car travel and substantial growth in air travel. So that is the perspective against this issue is being reported in these parts of these sections of the Oakervee review.
Mr. Mouldy, if a reader had clicked on the link at note 31 to paragraph 5.31, would that have taken the reader to some bit of detail about the carbon emissions issue? If they'd wanted to. Bottom of page SB 149.
Yes, it would, I think. I have to confess, I haven't looked at that link in the run-up to this hearing, but my understanding is that it would. If I'm wrong about that, my lord, I'm sure someone will send me an email and I will correct myself.
All right.
But I do know that HS2 Limited has reviewed its projections of the carbon emissions resulting from construction of the railway on a relatively regular basis.
Thank you.
All right. And you're able to take instructions relatively efficiently through email at the moment, are you?
Yes, I'm just going to see
if you want to pause to send an email to your instructing
that people are listening, and they will they will let me know if my answer is correct.
I assume that.
Yeah. Lord, so just to make good the overarching importance of lighting upon a mode of transport, the provision of a mode of long-distance transport provides the best opportunity over time to reduce UK transport-related carbon emissions. I draw the court's attention to a document that was published about a week before to proceed with HS2 was made in early February. It's the first of Mr. Moran's exhibits, which you find at you'll find in your at page 11.
Yes.
It's a document heading 2018 UK greenhouse gas emissions final figures, published on the 4th of February 2020. And the second indented bullet says this: emissions from transport fell by 1.4%, 1.8 million tonnes of carbon dioxide in 2018, their first fall since 2013. Despite this, transport remains the largest emitting sector, responsible for 28% of all greenhouse gas emissions in the UK. Transport emissions are only 3% lower than in 1990, as increased road traffic has largely offset improvements in vehicle fuel efficiency. So, as recently as a few days before government took the decision that is before this court, that was the published position and the contribution that car-based transport is making in terms of impeding the progressive reduction in overall UK carbon emissions. So one can see why it was that the Oakervee Review report, albeit in cautious terms, reported HS2 as presenting the best opportunity over the longer term, as compared to those other modes that I have drawn to attention in paragraph 5.32. And when one understands the matter, and one understands that it is that comparative assessment that the report is focusing on in those paragraphs that Mr. Wolf complains of, one can understand why the report felt able to say, if you want to realise that benefit over time, you have to accept that you will have to manage the short-term impact of construction. But that is an impact that you would have to manage whether it be rail or road or aviation. And the reason why we, in our skeleton argument and through the evidence of Mr. Moran, the reason why we have submitted that it was not necessary for the report to say more than it did about the legal implications of accepting that short-term significant contribution for carbon emissions is because the Climate Change Act and the Carbon Budget Mechanism and the Clean Growth Strategy was designed to enable those impacts to be managed within the overall framework of managing the progressive reduction in carbon emissions over the lifetime of the annual carbon budgets. Phase 1 is currently expected to be constructed by the end of this decade and to come into operation in 2030. HS2 Phase 2A is currently expected to come into operation at about the same time, with HS2 Phase 2B to follow towards the end of the 2030s. You can see that on that basis, although there will in the immediate coming years be a need to manage the construction impacts of HS2 within carbon budgets and within the strategy, well before 2050, those benefits, those longer term benefits Mr. Oakervee refers to in these passages of his report, may realistically expected to begin to be realised. Now, there is no overarching legal framework on those that Mr. Moran refers to and we refer to in our skeleton, which it required government to approach the matter in a way, in any different way, or any more intensive way than I have just outlined. In short, ministers, again, my Lord Justice Green's approach, what is the least that ministers can be assumed to have had in mind? It is reasonable to assume that the reasonable reader of this report would have recognised that for a decision maker dealing with these matters in February 2020, that we would have been aware of the Climate Change Act and the Carbon Budget Mechanism and the Clean Growth Strategy. Well, certainly that ministers would have been aware of that. Mr. Moran, in paragraphs, I'll give you the references in the electronic bundle index. In his witness statement, he deals with the approach that government as a whole is taking to managing the impact of constructing infrastructure schemes. In that context, in paragraphs 22 and 23 of his witness statement, and looking specifically at HS2 in paragraphs 29 and 30. For the reasons we've set out in our skeleton, we say that was enough to respond, if you will, to the challenge that Mr. Wolfe puts forward, that notwithstanding that, as he accepts, both the review report and ministers were aware of the fact of the short-term construction impact of HS2, nevertheless, they didn't make that basic leap between that impact and the fact that there's the legislative and policy tools in place to enable it to be managed within the overall progressive carbon reduction strategy.
Mr. Mould, can you help on this? Do you or not seek to emphasise that in this case, if you will, by contrast with the Heathrow third runway case, ministers demonstrably did take account of the Paris Agreement and its implications, whereas in the other case they demonstrably did not?
I certainly say that in this case they did, yes. And I also say that Mr. Wolfe does not accept that this is a valid distinction. But I also say that if your lordships, and I say this advisedly, simply remind yourself of the reasoning in paragraphs 222 and following in your judgment in that case, both in respect of section 5 subsection 8 and section 10 subsection 3 of the Planning Act 2008. The case being made by, amongst others, Mr. Wolfe, was that there had been a failure to discharge a statutory duty. In each case, the Secretary of State had failed to do what Parliament had required him to do, in other words, to take account of material considerations. So that was an absolutely orthodox exercise in viewing whether a statutory duty had or had not been fulfilled. This case is completely different. There is no specified lexicon of material considerations in this case. There is no statutory duty. And that adds colour and force to the point your Lordship puts to me. That what we can say here is that ministers had both the current legal position under the Climate Change Act, following Paris, and the factual position drawn to their attention. And it is simply, I would say, unarguable. But if your Lordships find it arguable, that they should reject the submission. That notwithstanding those matters, that nevertheless the Cabinet was guilty of a Wednesbury error here, and that in that it can be inferred that Cabinet failed to recognise that appropriate action would be needed in order to manage the construction effects of HS2 within the statutory framework of carbon budgets and the policy framework of the Clean Growth Strategy and other policy techniques for delivering on progressive carbon reduction. And that is my submission in response to Ground 3B.
Thank you.
Lord, I note the time. I wonder if just in a moment, perhaps in no more than a few moments, I might just respond briefly on the legal framework.
Oh yes.
In a nutshell, I invite this court to approach that issue in the same way as did the Divisional Court in its judgment paragraphs 46 to 57.
Yes.
And we've dealt with we've made written submissions in our skeleton at paragraphs 23 to 25. There are 2 or 3 short points. Firstly, the cases to which Mr. Wolfe refers, Hunt, the HS2 Action Alliance case, the Buckinghamshire case that is, Kohler, Stevenson, and as I've just indicated, the Heathrow case, and the Brackley case, those were all cases in which the court was reviewing either whether a statutory duty had been discharged correctly, or whether a statutory procedure had been followed correctly, or whether common law rules for fair consultation had been properly fulfilled. The second point is that the Health Associations case, which you have at tab 14, is authority for the proposition that it is Wednesbury unreasonable for a decision maker to make a decision in complete ignorance of legally material considerations and to seek to justify that decision on the basis that his officials had taken those considerations into account. That is dealt with in some detail in the judgment of Lord Justice Sedley, but it is encapsulated conveniently in paragraph 74 of the judgment of Lord Justice Keane at page 181 in the electronic bundle.
74.
Yeah. You'll see, he says, the implication of Mr. Cavanaugh's submission, as he frankly acknowledged, is that a minister who personally makes a decision of this kind can do so validly even though in complete ignorance of an important and highly relevant consideration. So long as his civil servants know about it, I cannot accept that is the law. I would not seek to dissent from that proposition. But he goes on to say in 75 that the real question is whether, in the light of that which was known to the decision maker, whether it can be said that a consideration that the decision maker was legally required to take into account had been left out of account. And that is the pre-New Zealand case and the seminal judgment of Mr. Justice Cook. And one sees that helpfully encapsulated in the judgment of Mr. Justice Bennett at page 80, at paragraph 81. He said, and in my submission this is the law, at the bottom of page 182 of the bundle, if the discretion is unconfined by the terms of the statute, the court will not find the decision maker is bound to take a particular matter into account unless an implication that he is bound to do so is to be found in the subject matter, scope and purpose of the act. Here, the position is a fortiori because there is not even an act. This is, as the Divisional Court said in their judgment at paragraph 53, this was the exercise of a common, at most, the exercise of a common law power, a political decision.
53.
Paragraph 53 on core bundle, page 100. In my submission, the Divisional Court approach is entirely consistent with authority in the, as I've just shown you in the National Health Service Association's case. And so, insofar as it is necessary for Mr. Wolfe to invite the court to infer that there was a failure to take account of a material consideration in the Wednesbury sense, he has first to show that that consideration was one that, in the exercise of a pure power, the Cabinet was legally obliged to have regard, and secondly, that they failed to do so. The question doesn't arise in relation to ground 3B, because as your Lordship has put to me, it's clear that the fact of construction emissions was taken into account. In my submission, it cannot possibly be inferred on the basis of the analysis I've just set out that Cabinet failed to take account also of the fact that those emissions would need to be managed within the statutory and policy framework. And in relation to ground 2, it cannot possibly be inferred that the reasonable reader, Cabinet, reading paragraphs 6.14 to 6.21 and conclusion 8, failed to take account of the fact that HS2 had been the subject of comprehensive environmental assessment, certainly so far as phase 1 is concerned, and that that assessment had been considered by the Oakervee review as part of the existing evidence to which the Oakervee review had been asked to direct its attention. Now, the Hunt case, on which Mr. Wolfe now relies, says nothing useful to this court, for the simple reason that Hunt was a case where the decision, both at first instance and in the Court of Appeal, was rooted in the statutory requirements which relate to the performance of the public sector equality duty under the Equality Act 2010. It says nothing more about the principle which I have drawn to your attention in the Health Association's case than is set out in that case. It does no more than to apply it. But it applies it in the very different circumstances of a case where there was a statutory duty in play and a procedure against which that duty was to be discharged, which is completely in contrast to the circumstances of this case. So it is not an authority which is of any assistance to this court. Lord? That's all I want, unless I can assist her, that's all I wanted to say by way of oral submission. I'm just checking, I have a message about that link that will just, I think what I am being told is that my answer was correct. Yes.
Well, thank you for checking that, and I'm grateful both to you and to those instructing you for doing so promptly like that. Thank you. That is all you wish to say.
It is.
By way of oral submission.
I'll rest on my written submission related to those other matters, if I may.
Right, you are. Thank you very much, Mr. Mould. Yes, Mr. Wolfe, your reply.
I'm grateful. Can I start in a sense where Mr. Mould ended with his reference to the cases, the National Association case,
yes.
Hunt, Kohler and so on?
Yes.
Can I be very clear what we are not relying on them for? We are not relying on them for issues around a challenge that focuses on a failure to take into account material considerations. That is simply not their purpose in these submissions. Their purpose is to remind the court of how the court approaches the information known to a decision maker or not known to a decision maker, what inferences the court can draw in relation to that matter, and how it approaches that in particular, this is the Hunt case, in the context of a decision taken by multiple people. As I say, we are not raising some submission that some material consideration in some abstract sense was missed out, or that some immaterial consideration was taken into account. Our focus is much more narrow and specific than that, and I hope it's made clear in our grounds 2 and 3, which I'll come back to in a moment. Picking up the ground 2 points, if I may, in that light, we are also not complaining. We are not saying that somehow Mr. Oakervee and his team didn't live up to the job that was set for them, or that they missed things out in a failing to take into account material considerations kind of way. The simple and only point is how what they provided would have been understood by the decision-making cabinet members for the purpose of the cabinet members taking the decision that they were taking. And that does not depend in any way on whether that decision was statutory in foundation or not. It was a public law decision, the basis for which the court can nonetheless, and here nonetheless is being asked to, scrutinise. Nor is that decision or its nature changed by being given the label political. A great many public law decisions with which the court is concerned could be given the label political. This was a decision on whether to go ahead with the project, evaluating its pros and cons. That was the exercise embarked upon and explained repeatedly through the announcements, through the Oakervee report, and through the decision that came out of it. It was a decision on the pros and cons. And for that purpose, the decision-making cabinet members needed to understand the information before them and what it was telling them and how far it went. And our simple submission is that they would have understood it to provide them with a basis to assess the environmental impacts insofar as they needed to do so for the purpose of making this decision. That was in the context of the benefit cost review having significantly changed in the intervening 3 years. So the overall balance of pros and cons now felt to be re-struck. New BCR numbers, even if environmental impacts were the same, which we have canvassed, I won't go back to that, the balance was still nonetheless inevitably for reconsideration afresh. You couldn't, within that process, that fresh consideration of pros and cons, put to one side, as Mr. Mould's submissions would have it, part of the picture. So even if the Oakervee report simply said those things are inevitable, those impacts are inevitable, that was not in any sense discharging or explaining to the members of the cabinet the thing that the Oakervee report and the surrounding materials would have led them to think they were getting. Just because impacts are inevitable, that doesn't tell them what the scale of the impacts is in order to re-evaluate that benefit and overall pros and cons benefit. Putting them to one side as inevitable is no answer to that point. The reason we then get into the question of what was known by cabinet members and the Hunt and so on considerations is because the respondents' answer to that, I need to be very clear about this, they do not say that ministers had enough information arising from the Oakervee report to make the decision. They have never rebutted that proposition in our pre-action letter or the pleadings. Their answer has always been, don't worry, cabinet members had additional information in the form of briefings, ministerial materials and so on. So we only get into that question because of the respondents' response to our claim. We are not the ones trying to find material in there. We are the ones who are saying, if it is your case that the gap in the Oakervee report is met some other way, which is the respondent's case, then you show us the materials. Either show us the information that would fulfil the gap, or show us something which says that ministers were told, don't worry, you need more information into the Oakervee report, here it is. Any kind of signposting to that effect. There was no signposting in any document before the court to say that ministers needed to look further than the Oakervee report for those things. Mr. Mould says, for example, anybody reading the report would have realised that there would be noise or impact on other impacts like that. Well, that may be, but there is nothing in the Oakervee report that tells the ministers or the cabinet members about the wide range of very specific, not generic like noise impacts, that were in play here. Some of the things that were identified in the NGO materials. So ministers, as it were, common sense about the impacts of a scheme would not have led them to have, somehow from a process of osmosis, the kind of information that would fill the gap left by the Oakervee review. That is the difficulty here, which is their misunderstanding, because of the way it was being put to them, of the nature of the information they were getting. That is not an abstract complaint or a pre-NZ kind of basis. So Lords, we say the kinds of things that Mr. Mould says about the cabinet papers it is fascinating, but doesn't get him home at all. The suggestion, for example, that because the cabinet manual says that ministers will be provided with appropriate briefings, the court can assume that they were provided with appropriate briefings. That gets one nowhere. That gets one nowhere. You simply cannot make that leap of inference. The problem here is that cabinet members would have read these materials in the context of the other materials and thought this was sufficient for their purposes, and it wasn't, and there's no dispute about that. Well, that is ground 2. In relation to ground 3b, again, what the court is being asked to do is an absolutely enormous inference as to the legal understanding of cabinet ministers. The court is being asked to infer, and that was exactly the word that Mr. Mould used, that because the cabinet members were told that there would be significant greenhouse gas emissions from construction, they would then understand the legal implications of that. They would understand how that would fit with carbon budgets and so on, and therefore with that key pillar of the implementation of the Paris Agreement. That too is an inference too far. They were told on the one hand there will be an upside long term that helps the government's net zero commitment. They were told on the other hand, on the other side, there will be a short to medium term greenhouse gas emissions impact, but they were not told of the legal implications of that, and the court simply cannot infer that a cabinet member would know that, nor can the court infer that the cabinet briefings would have told them that. Nor, just to pick up the point that the Lord Justice Haddon-Cave asked about the link in paragraph 5.31, would they have got that from that? We don't need to look at the document, we only need to look at the footnote reference to see that that document is dated November 2016. So by definition, it will not have taken into account the Paris Agreement provisions, let alone the carbon budget and the CCA obligations that have followed from Paris. It is simply the wrong date, and I'm pretty sure, we'll check if necessary, it actually doesn't make those points anyway, but one gets it simply from the date of it. But even if that were wrong, it absolutely falls into the category of materials in relation to Hunt, where giving somebody a link where they might find a document cannot lead the court to assume that they all follow that link. You will recall in Hunt that the summary equality impact assessment document included for council members in that case a link that would allow them to download the full document. And this court said just because they were given a link would not have led them, or we can't take it, would have led them to follow the link to get the further information. And that was a case where the further information was on that link. In my submission, there's no evidence before the court to show that the further information was on this link. So again, Mr. Mould is simply left with that bald proposition that cabinet members would understand the legal implications of short-term greenhouse gas emissions. And just to remind the court, the scale of them is the same scale as the benefits that are then claimed for the following 60 years of operation. So they cannot be dismissed as being incidental. One of the other things that Mr. Mould said about the assessment of greenhouse gases was he said this is really about looking at alternative modes of transport. And therefore what one is concerned about is the alternative modes of transport. And he said on that basis, therefore one can assume that there would be greenhouse gas emissions of putting in place any mode of transport. And he said that the two alternative things in play here were either new motorways or new airports. Now let me just pick up that last point first. If you look, I won't take you to it, supplementary bundle 224, there is a section of the Oakervee Review report which explains that one of the alternatives to HS2 is increasing the capacity of the existing rail network. Mr. Mould didn't mention that as an alternative. He referred only to increasing airport capacity or road capacity. There were other alternatives in play, including amending the existing rail network. Indeed, as it happens, that's what the applicant would favour. But if one says, standing back as Mr. Mould does, what was in play here was a comparison between the greenhouse gas emissions of those things, there is absolutely no evaluation of that whatsoever in the Oakervee review report. So you cannot put to one side or belittle the lack of focus on the Paris impacts of the construction of HS2 by saying this was a comparative exercise with motorways or airports. But even if that were right, which it's not, even if that were right, there's simply no basis to say, well, they're bound to be similar impacts, so you don't need to evaluate this one. They're all going to have impacts. Well, they might all have impacts, but not necessarily the same. So none of that gets Mr. Mould anywhere close to being home. Mr. Moran's point, Mr. Moran tells the court about how the impacts of this project will be managed within the government's greenhouse gas strategy, clean growth strategy, and so on going forward. And that is no answer. The submission I made before lunch, I make again. That is no answer when consideration of the Paris Agreement implications was obviously material to this decision. It is obviously to be welcomed that these impacts will be looked at later as part of another process, but that is not a substitute for looking at the obviously material component at this stage. And as I've indicated, obviously material Paris equals obviously material CCA 2008 carbon budgets. So that is simply not an answer. Again, we cannot make any assumption about what the Cabinet were told in Cabinet papers or anything like that, because we simply haven't been given the information. So none of those gaps can be plugged. Lord Justice Lindblom then made a comparison with the Heathrow case. Can I just make sure we have a proper understanding of what we say the comparison is with Heathrow? In Heathrow, in the context of the exercise of the discretion, one of the obviously material considerations of the exercise of that discretion was the implications of the project for the Paris Agreement. That does not turn on the provenance of the consideration, the discretion in play. Because in both that case and in this case, the decision maker was in fact looking at climate change impacts. And the point is, once they look at climate change impacts, mandatory in that case, by election in this case, Paris implications were obviously material. And of course, my Lord Justice Lindblom is right to say that in that case there was no consideration at all of Paris, no consideration at all. But that doesn't answer the point here, because as I hope explained, the consideration of the Paris implications here was limited to the benevolent side of the project, its contribution to net zero, and not its harmful side, the impact it would have detrimentally on meeting carbon budgets under the CCA 2008. And that latter component required Cabinet members not only to understand the numbers, the facts of the greenhouse gas emissions, but also their legal implications. You don't take into account the Paris Agreement simply by knowing that there are some numbers there. You take into account by understanding the legal implications of what you are being told. And as I said, Mr. Mould's only answer to that is to invite the court to infer that Cabinet members would understand those legal implications without them being told. In our submission, that's a step too far, given that one, in hump terms, has to somehow work out whether all the Cabinet members did that. And there is absolutely no basis in our submission for the court to infer that all the members of the Cabinet who made the decision on the 20th of February would have a proper understanding, or a sufficient understanding, of greenhouse gases and the legal framework that surrounds them, including not just the headline figure which is in the popular news, the net zero implications, but also the path to Paris stuff around carbon impacts and the carbon budget. So my Lords, we of course recognise that the nature of the failure to have regard to Paris in this case is a different one. It's not as binary as in the Heathrow case, but it is nonetheless, we say, an unlawful failure because the key component, the key detriment in greenhouse gas terms was simply not understood in legal terms by the decision maker. So my Lord, we invite the court very much to focus on the case as we put it, not on the way the case Mr. Mould characterises our case, or on the way that the Divisional Court appears to have misunderstood our case, but on the way that we put our case to the Divisional Court and to this case. It is very simple in relation to both Ground 2 and 3B. They are both, we say, light touch public law evaluations in the ordinary way of a perfectly ordinary public law decision. the nature of which is not changed by it being labelled or it being taken by the Cabinet. There is no rule of public law that says that the Cabinet is not subject to the same scrutiny by the court as any other decision maker, such as the local authority in the Hunt case. So, in other words, we do say on that basis that both grounds are plainly arguable and we say correct. We invite the court to grant us judicial review permission and to allow the judicial review on those two grounds, and then make declarations accordingly and quash the decision. That will allow, let me just finish this way, that will allow the Cabinet to make a properly informed decision on a proper understanding of both the environmental impacts and the greenhouse gas implications, and take the decision in the round, so that they are weighing on the one hand the diminished benefit cost ratio, and on the other hand the continuing and indeed in some instances increasing environmental impacts, to make the decision that they thought perhaps they were making, but in fact on analysis they weren't making. That therein lies the legal error. So we say that is the appropriate course, and unless the court any further questions, those are our submissions.
Let me just make sure that neither of my colleagues does have any further questions.
No, thank you.
Lord Justice Haddon-Cave does not, Lord Justice Green does not, and I have none at this stage, Mr. Wolfe. Thank you very much. I should like, on behalf of the court, to thank, first of all advocates, leaders and juniors, for the very great care they have devoted to the case and the assistance they've given the court, both in the preparation of skeleton arguments and in the oral submissions we've heard today. Thank you all very much, not least because we've had to operate within the necessary constraints of a COVID-compliant hearing. Thank you all very much. We also extend our thanks to those, as it were, sitting remotely behind for the efforts they have made in getting the case ready for the court in relatively short notice and in the presentation of it in the papers submitted. We thank them as well. We thank also the court staff who've made the hearing possible and have helped it to run as smoothly as it has. We thank them, though they're not all in court to hear it. We've managed the hearing within the day and without too many technical obstacles to our progress, and we thank those who've made particular efforts when things have gone wrong to put them right swiftly. Thank you all very much. We're going to reserve our decision, and judgment will be handed down, I'll say, in the normal way. That means in a COVID compliant way, with the procedure that operates at the time of the hand down. We do appreciate the urgency of the matter, which lies of course behind the fact that we've arranged for an expedited hearing of it. There will be no need for attendance, that's to say remote attendance, at hand down. Thank you all very much.
Thank you.
All rise.